5 seconds to go. Start. To decide the objection that limited notice having been issued at the time of admission of the intra-court appeal and the appellant's grievance being addressed, this court ought not to enlarge the scope of the appeal. We have perused the documents on record, including the inquiry report and other relevant materials. At the outset, we propose to deal with the objection raised by Ms. Nupur. It is true that limited notice was issued by the division bench while admitting the intra-court appeal. However, a reading of the impugned order does not reveal that the division bench, while disposing of such appeal, considered the sole point on which limited notice was issued. On the contrary, arguments were advanced by the parties on similar lines as advanced before us, and after noting the rival claims, the division bench proceeded to dispose of the appeal by holding as follows. In the present case also, the petitioner has put in service of 34 years and not an iota of material has been brought on record to even remotely suggest that the writ petitioner had been a troublemaker or undisciplined employee or habitual of absenting himself from work without permission. On the contrary, the factors that ostensibly appear to have influenced the competent authority have also been candidly pleaded and brought on record, that is actively pursuing litigation in which the highest authority of the department, that is Principal Secretary Health and Family Welfare Department Punjab, was as such a party respondent by name as contemner in COCP number 2304 of 2013 titled Dr. Bhupinderpal Singh Gill versus Srimati Vinnie Mahajan and others. No material has been brought to our notice that the aforesaid factual aspect was ever denied or refuted or appropriately dealt with at the time of imposing the punishment. Keeping in view the above discussion, the material available on record, ratio of the judgments referred to, and the peculiar facts and circumstances, we are of the considered opinion that the punishment inflicted on the writ petitioner, being a 2% cut in pension in perpetuity, even if the finding with regard to the charges is left untouched, is disproportionate to the misconduct and is sufficient to show the conscience of the court. Thus, the writ petitioner does not deserve to be treated any differently, and as such, taking a consistent view, the present appeal is liable to be allowed partly, and the order of punishment deserves to be modified accordingly. Therefore, the ends of justice would be met if the impugned punishment is modified to be for a limited specific period other than being in perpetuity, that is with cumulative effect. Nonetheless, the same would still act as a deterrent for other employees to discharge the duties in a proper manner and remain careful to follow all instructions issued from time to time. Accordingly, the order dated 26 February 2021 and the order dated 28 April 2021 passed by the writ court are set aside, and the order dated 11 October 2019 Annexure P13 passed by Principal Secretary Punjab Government Health and Family Welfare Department imposing 2% cut in pension with cumulative permanent effect is modified to that of 2% cut in pension for a period of 5 years. Consequently, full pension would be restored on the completion of 5 years period from the date the inflicted punishment has been effected. In view of the approach adopted by the division bench in examining the contentious issues arising before it, we consider the objection of Ms. Nupur to be without substance. Even otherwise, issuing limited notice at the stage of admission does not bar a constitutional court having inherent powers to pass such orders as the justice of the case before it demands to enlarge the scope of a petition appeal at the stage of final hearing. Any observation that the court may choose to make while entertaining the petition appeal by issuing limited notice ought to be regarded as tentative. Such observation cannot limit the court's jurisdiction to consider the controversy as raised in its entire perspective. Whether or not the court would enlarge the scope is, however, a question which is largely dependent on the facts and circumstances of each case. If the court seized of the petition appeal considers that the justice of the case before it demands enlargement of the scope, notwithstanding that a limited notice had been issued earlier, the court's powers are not fettered, particularly when enforcement of any fundamental constitutional right is urged by the party approaching it. We therefore see no reason to accept the objection of Miss Nupur and show the appellant the door at the threshold. Having dealt with the objection, it is now time to consider the merits of the appellant's claim and decide the broad issue. The appellant applied on 27th January 2017 for availing leave on 28th, 30th and 31st January 2017 to attend proceedings pending before the High Court. Since the details of the proceedings have been noted by the division bench and the same have not been disputed by the respondents, we refrain from referring to it here. The case of the prosecution was that the appellant had proceeded on leave without the same being sanctioned, defying the directions of the Election Commission and the higher authorities, and without participating in the Pulse Polio program. The allegation levelled against the appellant was sought to be established by the prosecution by examining two witnesses, a clerk PW1 in the office of the civil surgeon and a senior assistant PW2 in the branch office of the Director Health and Family Welfare. Referring to the records, PW1 gave a statement that the appellant proceeded on leave on 27th January 2017 without getting his casual leave sanctioned and without handing over charge of his post to anyone. The appellant was informed of non-sanction of his leave by the senior assistant in the office of the civil surgeon on telephone, to which the appellant responded by saying that he be not harassed by making phone calls and also that since he has no duty for the Pulse Polio program, he would take legal action. Reference was then made by PW1 to a letter dated 6 January 2017 of the Secretary Health and Managing Director Punjab Health System Corporation Punjab to the effect that grant of leave was closed due to election code in Punjab and that directions had been made by the appropriate authority of the election office keeping in view the election code that leave be not granted to any official. However, despite knowledge of the same, the appellant had proceeded on leave. In course of cross-examination, PW1 stated that no call detail is available regarding the telephonic message purportedly given by the senior assistant to the appellant, and it is only the senior assistant who would be in a position to throw light because PW1 did not have any record of conversation. It was also admitted that on cancellation of leave, separate letter was not written to the appellant, also that as per the record, no duty had been assigned to the appellant. Stop.